Right out the gate, we're dealing with multiple felonies, burglary of a habitation and credit card abuse. That's serious time. But notice, the defense is already angling for probation instead of prison. Big ask, considering the rap sheet about to unfold.
Good morning, sir. You're Justin Living. And Mr. Living was previously here, entered pleas of guilty to the third-degree felony offense of credit debit card abuse and the second-degree felony offense of burglary of a habitation. The agreement was for a cap of 10 years to run concurrently on each. I've gotten the PSI as well as some letters and information that Mr. Kimler sent on Mr. Living's behalf. Has everyone had an opportunity to review all of that?
Yes, Your Honor, we have.
Are there any additions or corrections to the PSI?
No, Your Honor.
Mr. Kimler, you may proceed.
Your Honor, looking at the PSI, I'm sure the court...
Mr. Kimler.
I'm sorry, Your Honor. Looking at the PSI, I'm sure the court has noted his felony criminal history. I would just note that just looking at it, there's a lot of material in the PSI, but in closer inspection, much of this was either refused or dismissed. I think it looks like what he has is, as far as felonies, would be a burglary of a building from 2012 possession. 2012 looks like it was probably a 1244, and then another state jail case from 2017, and then the case where he has his TDC.
Here comes the defense playbook. Minimize the past convictions, emphasize dismissals, and paint probation as a shot at redemption. But let's be real. Probation isn't just a second chance, it's also a gamble. Violated, and the punishment range skyrockets.
And the only TDC case back in 2017 was injury to a child, elderly, where he got 4 years TDC. So, as I said, first glance, it looks like he does have significant criminal history. I would take issue with the characterization and the recommendations that indicated that his criminal history has continued at a steady pace since 2001, since it looks like many of the felony cases were either dismissed or refused. Mr. Living, as he stated in the pre-sentence reports, never had probation. In speaking with him, I think that he would benefit from the rehabilitative aspects of probation that are available to him. There's a suggestion that he successfully go to the moral recognition therapy and successfully complete that. I think that he could benefit from that. He wants to make the changes he needs to stay out of contact with law enforcement, the criminal justice system. The letters I provided indicate he does have some support, family support out there. He wouldn't be doing this alone, so we're asking for probation in this. Of course, the court, since there are two cases, the court could defer one and give him a conviction on the other one. If the court were to defer the burglary of habitation, that would expose Mr. Living to the full range of punishment of 20 years. And then, of course, he already does have some state jail convictions, but the credit card abuse, again, is a third degree, so I believe that's just enhanced. The punishment range is just enhanced to a third degree, but the court could see fit to give him a conviction for that and still suspended and place him on probation. But if the court does defer the burglary of habitation, his punishment range would be 20 years if he does run afoul of probation instead of a 10-year cap that he's exposed to now. The court was just to refuse probation. So we asked the court to give him probation in both of these cases.
Thank you, Mr. Kimler. Mr. Nichols?
I'll disagree with Mr. Kimler's characterization as his criminal history not being that bad. You'll note that he's been mentioned in 83 reports by law.
Prosecutors turn, and wow, 83 police reports, victims dropping charges out of fear, and even a homeowner holding the defendant at gunpoint. This is the kind of detail that obliterates a probation argument. Audience question: if you were the judge, would you risk probation here?
Over the years, Your Honor. And he has continuously been violating the law since 2001. There's about 15 or 16, or at least a dozen misdemeanor convictions, all going back. And all these other felonies, it's noted in the report there's many instances where cases are dropped by victims due to fear of him. And I think it's important to note that the victim, in this case, in the burglary case, was threatened by this individual as he was being arrested, taken out of his garage. The individual, the homeowner had to hold him at gunpoint, Your Honor, when he found him in his garage in the middle of the night. His own explanation of that is he was running from the police and trying to hide dope, which really doesn't give him too much credit here. His explanation of the other credit card abuse case is that he got it from a dope fiend. That's his explanation. So I don't see how probation really seems to be a logical or deserved option at this point. I think the 10 years is appropriate and sufficient to both protect the community and punish his repeated behavior. I'll note for the court, as part of our agreement, I'm dismissing a violation of protective order case. So I don't see why probation would even really be a consideration. And I'll ask court to assess the full 10 years.
Mr. Levin wanted to address the court. Does he want to tell the judge?
Go ahead, sir.
I was wrong what I done, but I'm a good person. Like I can do probation. Like I ain't no bad person.
Oof. The defendant tries the "I'm a good person" defense. Here's the thing. In court, words like that carry zero weight if the paper trail screams otherwise. And in this case, the paper trail is 3 pages long.
You're not.
Yes, ma'am.
Mr. Living, I have to turn 3 pages to go through your criminal history. I haven't had an officer make the kind of statement in a PSI that I got in this one in a very long time. 83 offense reports have something to do with you in just Beaumont. Don't know where else you've been, if there's any others. 83. A good person doesn't have 83 police reports that have something to do with them. A good person doesn't assault family members over and over again and get time on misdemeanors and scare them or sweet talk them or whatever it is to get out of it on felonies. That is not a good person. I understand you haven't had probation, but you were barely out of prison and off parole when you did this. I completely agree. I mean, Mr. Kimler has pointed out some decent things, but there is no reason whatsoever that I would put you back on the streets in this community for any amount of time that makes any sense to me. So in cause number 24, DCCR 0288, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence.
Judge isn't buying it, and this is crucial. Judges often look at patterns of behavior, not just individual charges. Multiple assaults, dozens of reports, repeat offenses, that outweighs family support letters every time.
Find you guilty, and at this time, find you guilty of credit debit card abuse. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 1100, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you to 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These will run concurrently, which means together at the same time. I will sign the dismissal in the other case, which I didn't mention, which is the violation of a protective order where you're supposed to be staying away from somebody, and obviously you probably weren't. So anyway, that'll get signed. I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term.
Sentence delivered. 10 years on both charges, running concurrently. That means he serves them at the same time instead of stacking them. Small win for the defense, but still a decade behind bars. And remember, no appeals, since this was part of the plea
You
deal.
should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Kimmler. Good luck to you, sir. You can go back with the bailiff. Good morning. Are you Jacob Kozad?
Yes, ma'am.
Morning, sir. You're Alejandro Uribe?
Yes, ma'am.
And Mr. Uribe, you were previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. The agreement was for 5-year deferred adjudicated probation, and I received that pre-sentence report. Has everyone had an opportunity to review the report?
We have, Judge. Yes, sir.
So I guess my issues, or my only issue with going forward with this agreement is your status. You're not here, it appears as though you're not here in the United States.
Pay attention here. We're transitioning to the next case, and the dynamics totally change. From a defendant fighting to stay free to one tangled in immigration issues. Same courtroom,
Legally, and that
completely
you've been
different legal
removed
stakes.
before, and there's an ICE hold on you now. Is that correct? So, I mean, what does given a probation do? Just give him a probation and he gets deported and it sits on, we just let it go till he comes back again illegally or legally?
I'm not coming back.
I mean, there's ways to do it, obviously,
Right.
legally, but okay. I mean, do you think the best thing is to go forward with
I'll let you proceed on, Judge.
with the plea? I mean, and if you do get out, so let's just do this. We'll just go forward with the plea, and then whatever happens, obviously in federal court or with any type of new charges over there. It looks like I have been handed an arrest warrant from the United States District Court, Eastern District. So I think you will probably be taken from here. If there's a hold on you, you'll go straight over into custody, federal custody, and whatever happens over there happens. What I'm going to do is go along with this agreement. I'm going to give you a probation. If for some reason you get out during this probation period and you're here in Texas, then you obviously are required to go to probation, do everything you're supposed to, because if you don't, you could end up in prison for a very long time on this case. So what I'm going to do is find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, at this time, I'm going to follow the agreement, defer all proceedings, place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation if that becomes an opportunity for you. Obviously, if you do that, in this case, this is an excellent opportunity because you don't have this conviction on your record. And again, the other side of that, however, is if you do get out and you are here and you do not comply with the conditions of probation, you can be brought back into this court, found guilty of this offense, and sentenced anywhere in the range of punishment, which is up to 20 years in prison. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Probation will go over your documents with you today, and then we'll just see what happens. All right? You can give that back to Mr. Coleman. Thank you. Good morning. Are you Demetrius Miles?
Yes, ma'am.
And will your client waive the formal reading of the indictment? Mr. Miles, in cause number 24 DCCR 2478, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon. That's from November 26th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is Mr. Miles, is there any evidence of Mr. Miles not being competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in your case. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. All right, are you Gabrielle Smith?
Yes, ma'am.
And Ms. Smith, you were previously in court and entered a plea of guilty to the second-degree felony offense of robbery. The agreement was for a cap of 5 years in the institutional division of the Texas Department of Corrections. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
I have, Judge, if I may, for the court, my initial correspondence with Mr. Rojas was that she possibly had a tremendous amount of history out of Louisiana that I just couldn't get a grasp on based on the NCIC that I had. Obviously now probation has successfully done that, and I'm not sure that coupled with her behavior in the jail is even appropriate for the 5 year sentence. I agree with you that it's not.
It's not, yeah. I don't think it is either. So, Ms. Smith, I mean, your criminal history is pages and pages long. Hold on.
I'm sorry.
You have felony 1, 2, 3, 4, 5, 6, 7. You have 7 prior felonies for theft of goods.
Judge, I think if
That's wrong.
I was going over the PSI with you yesterday. By my count, I think we may have 4. Some of those are repeats, if I'm reading this right.
Yeah, that's wrong.
Well, if you look at the first page of felonies, she was sentenced to 12-month parish. That's not, it's called parish prison, but I think that's actually a misdemeanor.
Okay, so
And
let's.
so that one I don't think would count. On the
Okay.
second page, if you look at the first conviction, which is 1, 2, 3, 4, 5 down. That's
Well, the very top one is
okay, yeah, that one's well. Yeah.
a year in Department of Corrections.
And then the next one is number 5 down. That's the same one I think as 1, 2, 3, 4 down. That's the same amount of restitution, same time sentenced. And she said that was all the same case.
I've been locked up since 2016 to 19, and all those were supposed to be, from my understanding, I don't know what you call it when they.
So let's take one of those out that it's a mistake, okay? Let's take
nowhere near 7.
And then the same thing with the
1,
next
2.
following 2.
So it's 4 or 5. 1.
They all.
2,
What I'm
3.
saying is they're all.
Just because they ran at this,
I'm sorry.
listen,
I'm
just
sorry.
because your time ran at the same time doesn't mean that you weren't out there committing the same thing. Don't talk over me. Over and over and over again. The misdemeanors alone, I've got at least 8 theft misdemeanors, at least 4 stand up.
I'm sorry.
At least
My
4
baby
fel.
was ignorant.
Okay, at least 4 felonies. I'm not going to accept the agreement for a cap of 5 years. I do not think that is appropriate in your case, based on the nature of this offense, based on your underlying criminal history, based on jail incident reports that I've received. So I'm rejecting that offer, allowing you to withdraw your plea. I'm going to reset your case. You guys can negotiate. If y'all come up with something different that the state thinks is appropriate, then I will look at that at that time. You can go back with the bailiff.
I still have my bond. I still have a bond.
You have your bond is set at $7,000.
No, it was 10,000, but you did 1,000 for the.
You said a PSI bond.
Yeah, a PSI
Because
bond.
there was
No,
a question.
I'm withdrawing the PSI bond at this time. I am finding, based on the information that I have received in your pre-sentence report, that is insufficient. And at this time, I'm raising your bond to $40,000.
Ma'am,
You can go back with the bailiff.
$10,000. I'm not understanding how.
Well, what we didn't know and what I didn't know and what Ms. Molfino didn't know at the time that this offer was made was the extent of your criminal history in Louisiana.
Okay, well,
So
can I,
go back with the,
Can
go
I
back.
ask you one more question?
What, yes?
My original charge of assault on a police officer is not a robbery. She told me that I can, get re-indicted for assault on a police officer. I'm not understanding.
Judge, that was also my
Yeah, I'm not.
Hold on,
understanding.
and when someone else, I'll let you talk. And so when someone else is talking, you let them talk, all right? That's respectful for everyone. I gave you an opportunity to let Ms. Molfino answer.
Judge, in my review of the file, I think the case can be charged as either one. Obviously, with her criminal history, would show the amount of theft. This was an instance that was underlying of a theft that either got out of control and could be indicted as a robbery or an assault on a public servant. They're both the same second degree.
Right.
We will also, if we can't reach an equitable agreement that the court agrees with, be moving to use those Louisiana prior to answer.
Okay, all right. Mr. Rojas will go over all of that with you. You can go back with the bailiff.
I don't understand.
Ms. Smith, come back. Ms. Smith, come back come back.
I just don't understand.
You cannot understand, but you're going to be respectful in this court.
I'm not respectful.
You're not
Okay,
being
I'm sorry.
respectful.
I'm sorry.
Because I think you do understand, because this isn't your first time being in a court of law. You've been in it numerous times in Louisiana, all right? When you walk out of here, you walk out quiet. There's no attitude, because things can get worse and worse and worse instead of better and better and better, right? Go back with the bailiff. Let's try it again.